1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner, and thank you, counsel, for participating with the Court of Appeals in this oral argument via Zoom. We appreciate your ability to do this. We understand that Mr. Harris is having some trouble seeing us, but I understand, Mr. Harris, you can hear us okay. Is that correct?
Well, Your Honor, actually, I can see you and hear you fine. My video, you just won't be able to see my face.
Okay, great.
Audio only.
Thank you for clarifying that. When we begin the process here in just a few moments, we will follow the same procedure as if we were arguing in the courtroom here in Jackson or there in Nashville. So we'll follow those rules and protocol, which means essentially the appellant, each side gets 15 minutes to make its oral argument, and the appellant may receive rebuttal time if requested to the court. Before we start, let me introduce for you today Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything else to take up?
No, Your Honor.
All right, you may call the case.
Kia Winfrey versus Blue Car, Inc.
And we will hear from the appellant.
It please the court. I'm David Kozlowski with the Legal Aid Society of Middle Tennessee. And the Cumberlands, I represent Ms. Winfrey. I respectfully request to reserve 3 minutes for rebuttal time.
All right, sir. You may proceed.
The issue in this matter is very narrow. Specifically, the only issue before the court is whether the trial court abused its discretion when it dismissed Ms. Winfrey's complaint on the sole ground that counsel negligently failed to comply with Local Rule 20B. Now, this is a consumer protection matter, which Ms. Winfrey asserted claims against Blue Car in connection with the sale of a GMC Acadia in 2018. After the General Sessions Court dismissed her claim and the defendant's counterclaim, timely appeal was filed to the Circuit Court for Davidson County. That was in late July of 2019. On January 10, 2020, about 4.5 months after the Rule 20B timeline had run, we filed a motion to set on behalf of Ms. Winfrey. Rule 20B requires that a motion to be set within 45 days. We were late doing that. The defendant responded with a motion to dismiss, which the trial court granted. On behalf of Ms. Winfrey, we filed timely a Rule 5904 motion to set aside the dismissal. Blue Car responded without disputing any of the facts asserted by Ms. Winfrey in her motion and the attached affidavit of counsel. That motion was denied, resulting in this appeal.
What did the affidavit of counsel say as far as a reason to set aside the dismissal?
Well, the affidavit addressed basically the 3 factors that this court has determined are appropriate to consider when determining whether entry of a dismissal for failure to prosecute, as this is under Rule 20B, is appropriate. The affidavit explained how Attorney Tarpley had basically set this aside and failed to schedule or put on his schedule that he needed to submit the 20B motion. It indicated what other activities or what other responsibilities had as a supervisor at the Legal Aid Society. It set forth the nature of the meritorious claims that were presented in the amended complaint that was filed in Sessions Court on behalf of Ms. Winfrey, and suggested that there was no prejudice in the delay to Blue Car. And Blue Car had not, until we had moved to set the trial, Blue Car had not taken any action to seek a dismissal of this case, and in their response did not suggest that there was prejudice. So that's essentially what the affidavit of counsel indicated.
Was any countervailing evidence introduced by the appellee?
There was no testimony, there was no affidavit. There was basically in both the motion to dismiss and the response to the 5904 motion, Blue Card did not challenge any of the facts, any of the assertions made by Ms. Winfrey's counsel in the affidavit or in the motion itself. So no, there was no countervailing testimony, countervailing evidence presented.
Okay. And what did the trial court determine regarding the information submitted by you or by your client?
The trial court order merely stated that the first, at the motion to dismiss hearing in February, there are actually two orders that have been entered by the court to dismiss, and simply said failure to follow Rule 20B, and the order with regard to the motion to alter or amend simply said it was denied. There was no other explanation related to the factors that are relevant to evaluating whether a dismissal for failure to prosecute under Rule 20B should be set aside.
And what do you suggest the standard is that the trial court was required to utilize in examining this evidence?
Well, the standard has been set forth by this court in a number of cases that deal with appeals relative to Rule 20B. In the Bowers versus Guttergaard case, the three factors are whether the failure to comply with 20B was willful on the part of the appealing party. Second, does the moving party have a meritorious claim? And third, is there prejudice to the opposing party? Those are the factors that have been set forth by this court. There are probably 8 or 10 cases that deal with Rule 20B that have been appealed to this court from the Circuit Court for Davidson County.
Right. I don't think I made my question very clear, and I apologize for that. Here we have evidence that you have introduced that essentially is not controverted by way of affidavit that was presented to the trial court. The trial court made no determination regarding that evidence, but denied your motion. How are we to approach that in reviewing the decision of the trial court when we have this uncontroverted evidence?
The question is, what's the appropriate way the court should deal with this?
What's our standard then, I suppose, would be the appropriate question.
Well, the standard of review, of course, is abuse of discretion. But as we've indicated, the abuse of discretion standard is set forth in the Supreme Court in the Lee medical case. We've addressed that in pages 9 and 10 of our brief. It's an abuse of discretion standard, but the abuse of discretion is considered or reviewed based upon the three factors that this court has set forth, particularly in the Bowers case, and basing that on other opinions of appellate courts in Tennessee.
Well, I guess my question is, if the trial court didn't make any findings and your evidence is uncontroverted, then how do we know if the trial court abused its discretion when we don't know why the trial court ruled as it did, other than that's what the rule says?
Well, I think that, the clear assumption is, or the clear picture is, the trial court didn't look at these factors, and I think this court can, based upon the evidence that is in this record, and hold that on this evidence and on the factors that the trial court did abuse its discretion. And I hope—
Mr. Kozlowski, did you argue those factors to the trial court when you made your motion?
We did. We submitted a brief, and of course, briefs are not part of the record for appeals courts, but a brief that we filed looked fairly similar to the brief that we filed in this court. We did argue those factors, and the motion itself mentioned those factors, as did Mr. Tarpley's affidavit.
And Mr. Kozlowski, did you have a hearing on these motions, or did the court rule solely upon your pleadings that you filed?
The only hearing was oral argument of counsel. There was no testimony presented to the trial court.
So you did make a court appearance for the purposes of your Rule 59 motion?
Yes, although it was conference call. This would have been in early April, if I remember correctly, and COVID restrictions were in place. The court heard this by conference call. When looking at the factors, the threshold factor is, of course, whether there was purposeful or willful failure to comply with Rule 20B. And as Gordon Bauer is looking, we have the Maddox versus BPR case that indicates specifically that carelessness, inattention, or negligence conduct is not willful conduct. It's not purposeful. And the court also needs to consider, and this is included in affidavits, the involvement or participation in the party herself as being responsible for the delay. And it's uncontested that Ms. Winfrey had no involvement or no participation. It was counsel and not Ms. Winfrey who was involved. Again, this court has held that the sanction of dismissal under Rule 20B is designed for, quote, totally unresponsive parties, unquote. Secondly, again, there is no contest that that Ms. Winfrey does not have a meritorious claim. The amended complaint filed in General Sessions Court raised a number of consumer protection claims or issues, including the Federal Odometer Act and the Article 9 of the Uniform Commercial Code. Blue Car has not suggested that these are not meritorious claims. And finally, consideration of prejudice is the third factor to look at. No suggestion in this record that a delay of basically 4.5 months in requesting that the case be set for trial has caused any prejudice to Blue Car. And again, in Bowers, this court held that simply having to proceed to trial is not prejudice. We're asking the court, based on this record, admittedly limited record, that the dismissal of her claims, dismissal of Ms. Winfrey's claims, be reversed, be vacated, and this matter be sent back to the trial court for a scheduling order and to set a trial as promptly as possible. Unless the court has further questions, that's our argument.
All right, sir. Thank you very much. We will hear from the appellee, Mr. Harris.
Yes, sir. Can you hear me? Can you hear me, Your Honor?
Yes, yes. Just a second. Let the clerk reset the clock.
Yes, Your Honor.
All right, sir. We can hear you, and you may proceed. But if you would kindly introduce yourself, and then we'll hear your argument.
Very well. Good morning, panel. My name is David Harris, and I'm representing Blue Car Incorporated in this oral argument this morning before Your Honors. And just getting right into it, I want to point out something Mr. Kozlowski just said in the closing part of his arguments. And as that Rule 20B was designated, created with totally unresponsive litigants in mind. I think those are the words he used, totally unresponsive litigants. And Mr. Kozlowski is right. And in this particular case, these litigants were totally unresponsive for a period of 6 months and a day. And I'll get right into that timeline with Your Honors, because I believe a quick going over of the timeline is instructive, at least in my argument, at least so I can remind myself of how this timeline unfolded. Now, July the 12th, 2019, both cases were dismissed from the General Sessions Court. There was a suit and a counter complaint, and the appellant was the original filer, and I think the appellee, Blue Car, filed a counterclaim. So there were two General Sessions cases that were both dismissed on July the 12th, 2019. Now, the appellant made a timely appeal to the circuit court on July the 23rd, 2019. So that showed immediate action, July the 23rd, 2019, Your Honors. Not another thing happens in this case, Your Honors, until January the 20th, 2020. That's when the first request in the circuit court was made for a scheduling order. That is 6 months and 1 day. 6 months and 1 day. From the time it was appealed to the time that anything was done in the circuit court whatsoever, Your Honors. And so at the time it was dismissed, January the 20th, 2020, that was actually 181 days. And certainly after that, there was a flurry of motions in the 59 motion, and there was lots of activity going on after that. But we cannot ignore the fact that 6 months passed from the time it was appealed to circuit court to the time the first request to schedule was made. Now, if we start talking about the grand timeline of this case, this litigation started in 2018, Your Honors, at the General Sessions level. And these people have been litigating this case. And at this point, we sit here now, we're 2 years and I think 8 months into the attempted litigation of this matter. And Mr. Kozlowski points out that he sees no harm that has come to the case of the appellee. And I would have to disagree with that and say that Blue Car, if forced to go forward on this matter yet again, 2.5 years after the litigation began, then absolutely we're losing witness testimony or spoliation of evidence. The mere time that has passed certainly has diminished people's recollections of what have happened in this case. So I would say
was that argument made to the trial court?
Your Honor, I don't believe it was. I did not represent her at the trial court level.
Okay.
But I don't believe that particular argument was made. In fact, my notes tell me, and I don't have this in the record, but my notes tell me that the court was fixated on the amount of time that had passed. So therefore, the court was entertaining very few arguments about anything else other than the period of time that had passed.
Judge Stafford,
yeah.
I believe we've lost Judge Armstrong.
Yes, we have. I didn't know if he could still hear or not, though.
I believe he is gone.
I only see your face, Judge Stafford. I don't see anyone else now.
Okay, well, Judge McGee is still with us.
There she's okay, she's back on my screen now.
Okay. Hold on to your argument for just a moment, Mr.
Yes,
Harris. You're not going to lose any time, but we're going to try to figure out how to get Judge Armstrong back on.
Thank you, Judge. And in fact, I don't have many minutes left, Your Honor, so.
Well, you actually have 11 minutes left.
I understand. I'm sorry. I was getting through my own argument. I'm about halfway already, so. All
right, if you'll just hold on just a minute, we'll see if we can get Judge Armstrong back on. I think he's about to come on, I hope.
Yes,
sir. Judge Armstrong, are you there?
Yeah, I'm here now. I'm using my iPad. I don't know what happened.
Do you want to turn your video on or?
Let's see. Okay.
There you are.
All right.
Okay. What happened?
I guess you just decided to go get something to eat or drink. I don't know.
No, I didn't.
Okay. We good, Mr. Tivner?
Yes, Your Honor.
All right, Mr. Harris, you can pick up where you were.
Yes, Judge. Briefly recapping, period of 6 months and 1 day between the time the case was appealed to the circuit court to the time that the very first request for a scheduling order was made. 6 months, 1 day, 181 days. After that, a flurry of motions came, but 6 months and 1 day between the time it was appealed to circuit and between anything was requested of the circuit court for a scheduling order whatsoever.
Let me ask you a question, Mr. Harris, and I don't want to unduly characterize the action of the trial court, but based upon what you said just a moment ago, would you be comfortable saying, and would it be safe to say, that the trial court essentially only looked at the fact that this time period had elapsed and nothing had been done, and that's why the case got dismissed?
Your Honor, I don't know that I would characterize it that particular way. What I would say is that certainly the time period was the governing factor that the trial court was looking at. But honestly,
what else would you suggest that the trial court looked at?
Well, the trial court considered the extensive written motion or brief or memo. I forget what Ms. Winfrey's counsel filed, but the written instrument that they filed was, as Mr. Kozlowski said, very much it mirrored what they filed in this particular court in front of Your Honor. So essentially, what they filed here in front of this court is what they filed in the trial court, Your Honor. Certainly not word for word, but Mr. Kozlowski's own argument said that it was reflective of exactly what he filed in the trial court. So I would say that the honorable trial judge there at the trial court certainly took considerable time to consider the well-reasoned arguments of Ms. Winfrey's counsel. And although it didn't necessarily place anything in any kind of elaborate order or findings, it certainly laid down its decision. And I don't know that the trial court has to necessarily couch all of its reasons, although it would be greatly helpful at this level. Certainly the time that passed, Your Honor, was a governing principle. I do not think it was the only thing the trial court used to make its decision.
Okay, but let me, and you are correct. This is a motion to dismiss, and I don't think the trial court's got to give its reasons on a motion to dismiss, but was the only reason that you asserted on behalf of your client that this case should be dismissed would be the passage of time?
Yes, Your Honor. The passage of time as contemplated by Rule 20B. Yes, Your Honor. That would be a position.
All right. Thank you.
You're very welcome. And
Mr. Harris,
yes, Your Honor.
I want to make sure I understood your response to Judge Stafford's question. You're saying that the only thing that was argued on behalf of your client at the trial level was the passage of time?
No, Your Honor. What was argued I was not in on the conference call, and there's not a transcript of that conference call that Mr. Kozlowski referenced. However, I know that the trial court discussed the issues with both counsel. Now, I don't know how much weight the trial court gave the issues, but from all the notes that I've read, Your Honor, and that's all I have from it, I don't have a transcript of that phone call that happened, and I was not a part of it. From what I understand from the notes, the passage of time was the major principle upon which it made its decision, but certainly every other factor was discussed as well. And that's the best recollection I have of or the best estimation of what I can give, Your Honor, of what happened.
Thank you.
You're welcome. And yes, and also in our brief, we argue for potentially an award of attorney's fees if Your Honors find that under 27-1-122, that this appeal was taken with very little chance of success given the passage of time. And we would argue that the passage of time in this case, at this point, we're nearing 3 years since this litigation began. And if there were to be a remand of this case, it would go on another year, which could put us in the 4 to 5 year litigation range on this particular case. And we would call Your Honor's attention to that under our request for attorney's fees, that such a vision for a case that began at the Sessions Court level to go for 5 years is just something that I think we have to be careful about condoning, because it would be impossible, I believe, for either client to get what they were looking for after these many years have passed trying to litigate this particular case. So I would ask that this panel affirm the judgment of the trial court that the case was properly dismissed under Rule 20B, Davidson County Local Rules.
All right, sir. Anything else?
That's all I have, Your Honor.
Okay. Thank you, Mr. Harris. We will hear in rebuttal from the appellant.
Thank you.
Initially, Judge McGee, obviously the only record here as to what occurred on the conference call is the court's order, essentially just overruling without explanation the 5904 motion. I was there as opposed to Mr. Harris, and can tell you that the court simply heard the arguments and said denied. Don't know what was in the trial court's mind they looked at the brief or argument, but that was what occurred. And that's what the order indicates. Let me, for your honors, point out and address the time, which is the only argument being made by Blue Card. And this is a section this is a point that was not addressed in our brief or reply brief, and I apologize for that. But earlier this month, in rereading some of the cases, I came across what this court has said as far as time under Rule 20B and how that factor should relate to the determination as to whether a case should be dismissed for failure to prosecute. In the MDAH versus Allen case decided in 2015, and the Crom-Clark Trust case that we cite decided in 2006, which we cited regularly in the brief, this court referred to Davidson County Local Rule 18.01 in determining, or at least evaluating, what it means to have a case languish or a party to be totally unresponsive. In the MDAH case, it's footnote 4, and in the Crom-Clark case, it's footnote 5, where the rule 1801 is mentioned. That rule applies to cases that are initially filed in circuit or chancery court in Davidson County. And it requires that the plaintiff, the case either be concluded or that the plaintiff has moved for trial within 1 year of the filing date. In Crom-Clark, as I read it, this court kind of wondered why appeals from General Sessions Court are treated differently. And I think that is the focus of what is too much time as an initial matter or as a matter to look at. And that's what this court has given us guidance as to what that time means. The plaintiff filed the motion to set, admittedly not within Rule 20B, but roughly 5.5 months after the appeal was filed. That quibbling over time is not particularly relevant. We would ask the court we have in our briefs to overrule or to set aside, to vacate the order of dismissal and return this matter to the trial court for a trial. Thank you.
Right. Thank you, gentlemen. I appreciate you participating. I apologize for our technical problems. That's going to happen when we work with Zoom and video, but as in all cases, we will get through it, but we appreciate you working with us in this process. We will take this matter under advisement. We will issue an opinion at our earliest time available. Again, thank you, Mr. Hibner. If you will recess court until the call of the docket this afternoon.
Thank you, Judge.
This honorable court is now in recess until 1 p.m.
Thank you.
Thank you.